Coalition Media Network, here at the Go Local Live Broadcast Center at 90 Way Boston Street, yes, in the heart of the city we love. Facebook.com/The Coalition Radio, on the mighty Twitter at Coalition_radio, and CoalitionRadio.us, where these and future broadcasts can be found with a direct link to our YouTube channel. We've got a very special guest. He's joining us again tonight. Just with us just a few short weeks ago, Jim Manley. He is the senior attorney, if you will, of the, I'll call it the practice division, the enforcement division of the Goldwater Institute. They need new introduction on the coalition. They litigate, they legislate, and they opine on the most important issues facing Americans today and the liberty movement worldwide. He's got a limited time window, so I want to get right into the issues. We'll spare the niceties until the next segment. But Jim, welcome again. Thank you for coming back to the coalition.
Always a pleasure. Thanks for having me, Pat.
All right. So we in this week's episode, there are several issues that the Goldwater Institute has been litigating relative to, and I guess to oversimplify it, I'll talk about the forced inclusion or membership in the labor union issue facing Americans today. Give us a little background of what's happening.
Yeah, this is an issue that's been brewing for decades. Essentially, in a nutshell, public employees can be forced to pay for the cost of collective bargaining, even if they decide not to be a member of the union. It's called an agency fee. And the court has said that this is okay because while you can't force people to pay for political ideas that they disagree with, you can force them to pay for collective bargaining because labor peace is so important. And so we're going to allow this situation, which we understand is a violation or a burden on First Amendment rights, but we're going to allow it because labor peace is so important and because public employee collective bargaining isn't necessarily political. That fiction has gone on for decades now, and finally the court has shown a inclination to roll back that infringement and restore First Amendment rights to public employees, and really will have implications for members of any compelled association. So the big one that we're working on is mandatory bar associations. In 31 states, lawyers are required to not only have a law license, but join the bar association and pay dues to the bar association. And what that ends up meaning is that lawyers, just like public employees, are taken along for a ride with the association's political speech and end up unwittingly funding a lot of political speech that they may disagree with, but that they're forced to fund because they are because of the job that they have.
And this is an issue been forced union membership, and for the record, the coalition supports, I'll say, private labor unions, but would never support forced membership in any sort of association. Freedom of association is a fundamental right in America, and it's an expression of a multitude of constitutional issues, but first and foremost, your First Amendment. One of the issues that's cloudy, and again, the beauty of your presentations, you're often able to make accessible some of the more challenging legal issues to the average person. In states like Rhode Island, we are desperately trying to become a right-to-work state. Can you juxtapose right-to-work issues, union membership issues, and now you're actually going after, in a sense, public union membership issues? How does this all mix in together, or not?
Yeah, so one way of looking at it is applying the right to work idea to public employees, because it involves the same problem of compelled association and compelled funding of the union. So in the public employee context, even if you decide not to join the union, you still have to pay this fair share fee, this agency fee, to fund the union's collective bargaining, which is inherently political, because when a public employee union bargains, it's bargaining with the government about public policy, about how government employees should be compensated, about what their job duties should be, and what rules should govern their employment. And when you're talking about that sort of stuff, you're talking about what public policy should be. So you're having political discussions. And it's some of the work I do involves campaign finance. And one of the issues that we have in that context is fighting against this idea that fighting for the idea that money is speech. Mm-hmm. And there are a lot of people who think that spending on political activity shouldn't be covered under the First Amendment, or it should be covered under with a lower level of scrutiny from the courts.
Right.
But in this context, where you have people being forced to take money out of their paycheck to fund speech that they disagree with, everyone seems to understand that money is speech, and that forcing people to pay for speech that they disagree with violates the First Amendment. And the only reason that the courts have allowed it is because the unions have made this argument that it's necessary in order to have a functioning public employee union. But the facts on the ground just don't support that, because the last time the court looked at this issue was in a case called Friedrichs, and Mrs. Friedrichs is a public school teacher in California, where union membership is about 90% of public school teachers. And so the debate was over whether this 10% of objectors should be forced to pay for the union. Mm-hmm. Nobody actually made the argument that the union was going to fold if Mrs. Friedrichs was allowed to remain a conscientious objector. But the unions just don't want to give up that little bit of extra money, and so they're fighting for their ability to take money from every public employee, even if the employee doesn't agree with what the union's fighting for.
Right. It's certainly, to this audience, it's no shocker, if you will, that public employee unions play an outsized role in American politics, and as a result, the lives of every American, regardless of their participation in that union. Public employee unions also play an outsized role in the American stock market, because, I mean, whether it be a CalPERS or any one of the number of literally tens of thousands of public union trust employee benefit funds that exist in America today, they are amongst, in many cases, some of the most well-funded in America today. Because, quite frankly, in most states, their funding is considered an act of political expediency. So you have these organizations that play this outsized role, yet at the same time, demonstrably, there is very little accountability between membership and the political positions they evoke. And the danger there, of course, is you have an individual in a state like Rhode Island who might be shockingly a libertarian and find themselves in their union advocating for, well, I mean, in this day and age, equally egregious would be the support of either Donald Trump or Hillary Clinton or Barack Obama or who's that guy from Minnesota? He used to be a senator. So it strikes me as odd, and I don't, just on a practical level, why unions have never been, if you will, forced to break into two distinct operations: the management of the union and essentially their political activities through some type of political action committee, and why a member can't simply voluntarily pay a fee that it just simply goes to overhead. Have you seen that anywhere?
Well, so we see it in the bar association context a little bit, where the purpose in the public employee context is labor peace, and the line is that lawyers have to be forced to join bar associations in order to regulate attorneys. Mm-hmm. Now, the problem with that is that there are 19 states that don't require mandatory bar membership, and they still manage to regulate attorneys.
Right.
Large and small. Vermont and New York both have voluntary bars. The smallest economy in the country and one of the largest in the world. Mm-hmm. And so what we've seen in some states, Nebraska just did this, where the Supreme Court bifurcated the bar, and they created one part that had to do with regulation only, and one part that had to do with anything else. And lawyers were required to pay for the cost of their regulation, but not for anything else. Mm-hmm. And And that's basically, what we're advocating in our challenge to mandatory bar membership, is that attorneys can be required to pay the cost of the regulation, but they shouldn't have to join an association and fund anything else in order to practice their profession.
Right.
And public employees should have that same option. If they want to join the union and engage in the union's political advocacy, they should be free to do that.
Mm-hmm.
But the tricky thing is that the only reason that public employees exist is to collectively bargain with the government.
Right.
And so, said a different way, the only reason that public employee unions exist is for political activity.
Exactly.
It really isn't a part you can carve out. Everything the union does is political, and everything that the union does should be voluntarily funded for that reason, because in America we don't force people to take political positions that they disagree with.
Right, because the both the tragedy and the hypocrisy of the public employee unions is that they are essentially voting in their own bosses. And clearly, and just like you and I would love to have the option of voting in our own bosses, we're simply, if we suggest that, we're voted off the island. So the stress that it's put on at its most basic level, municipal budgets, state and local budgets, on up all the way to the stress it's created both on a personal level because of these demands. And these are unions very often that financially, we're not talking about, the days of some of the farm unions, farm work. We're not talking Cesar Chavez here. We're talking about unions that ultimately have operating budgets in the millions of dollars. And forgive me this, because when you're a libertarian, there's contradictions everywhere. But on its most superficial level, to me, unions being able to participate through the collection of dues in their, and then use those dues for political purposes, advocating, is an end run around campaign finance laws, because, quite frankly, if here in Rhode Island, I can only give $1,000 to someone running for office. If I'm a union member, I can still give that $1,000, and yet separately funnel another healthy chunk of change to these folks.
And I don't know if we've talked about this, but one of the case that I'm litigating in Massachusetts, we must have talked about this in the past, but it is challenging Massachusetts law that prohibits businesses from contributing to candidates, but allows unions to contribute.
Exactly.
And one of the arguments that we've gotten from the state is that, well, the business owners could just double dip, that the business could contribute money, and then the employees and the owners could contribute money. And the response to that is the one that you just proposed, that union members have a right to contribute to candidates, and the union itself has a right to contribute. The tricky thing with a public employee union is that they can also use non-member money for political activities if they are unclear about how to opt out of that spending, or if they manage to shoehorn that spending into their core purpose of collective bargaining.
I believe firmly one of several great opportunities missed by Mitt Romney when he ran for office was his rather infamous comments about corporations being people too. He had a wonderful opportunity there to really explain how in a lot of ways corporations are people. Corporations are people on a couple of levels that would be endemic to progressives and particularly to the Democratic National Machine. What I mean by that is that corporations in its totality represent the distinct interests of anywhere from one or two or a handful of people to thousands of people. Number two, those same corporations, as I mentioned earlier, play an outsized role in managing investment funds and pension funds. And as a result, in addition to being the corporation, the direct interests of the members of that corporation are reflected in that. So corporations are people. In the absence of people, corporations cease to exist. And they clearly, in my mind, should have, and I know this will make people nuts, but clearly, in my mind, should have the same rights to freedom of expression that everyone should have. I just fail to see why, when there are so many exemptions carved out for every 501c through 26 is carved out, and why labor unions are able to so overtly engage in the body politic, and yet individuals, because of their financial interests, are limited to that. Do you see that sort of ice dam starting to break now?
I think so, and I think that cases like Citizens United and Hobby Lobby, and then even in the Masterpiece Cake case, the gay wedding cake case, the court asked a question about whether the Masterpiece Cake Shop has any First Amendment rights because it's a corporation. So it's an issue that hasn't been totally resolved, obviously, because we've got Mitt Romney saying clumsy things about it. But it's an issue that's heading in the right direction, at least in the courts. Because, as you say, a corporation is nothing more than a group of people. In the same way that a union is a group of people, they have no purpose, and they couldn't exist without the people that formed them. So, and people that form a group don't lose their constitutional rights just because they've gotten together with a group of other people to exercise those rights more effectively.
Yeah, I don't think the founders envisioned some extra legal process, in order to fulfill bureaucratic or tax issues as a precursor to defeating those individuals' collective first rights amendments. It's free expression should be not only allowed and encouraged everywhere, and clearly the freedom of association issue. If you're, bake that cake, is possibly the most difficult and challenging issue for libertarians to go. If there's a third rail of electoral politics in America today, it is the freedom of association. And if you truly encourage freedom of expression and then as a result freedom of association, you can be branded as a racist, a terrorist, fill in the blanks of ad hominem attacks, when in fact you're just looking for pure transparency. If they don't want to bake that cake because they're bigots, quite frankly, it's more well known. They're sunlight, it does provide the harshest antiseptic. And we become more cognizant of people's true beliefs when they have to operate in an environment of free expression and free of association. So I mean, is that an issue? Do you think that we can overcome in this generation, or are we kind of screwed there, for lack of a better term? Did we?
We went down the other road, but. Am I losing you?
Okay, come back. We lost you there for a second or two.
Yeah, I think as a country we've gone down the other road to rely on government to make those decisions for us, and I think we're worse off for it. But I don't see much change in that area, maybe for the better. Although I think as we mature as a society and we become more understanding of individuals and individual differences, maybe we will begin to understand that we don't need the government making those decisions for us, that we are all adult enough to make those decisions for ourselves.
Right.
But I think that's a little ways down the road.
Yeah.
This is better public policy.
Now, we've only got a few minutes left, and Jim Manley has joined us. He's the senior attorney for the Goldwater Institute, an organization that we're very proud to be able to communicate with on a regular basis here on Coalition Radio. One issue I just have to ask you about, and this is, I know that you guys are addressing this at large, something about video killed the football star, or what?
I don't think anyone's come up with that here. We should steal that from you.
Feel free. But how did, unrelated issue, but how did we as a society get to a point where we've got a multi-billion-dollar entertainment industry whose participants have little or no profit participation in it, effectively, and that we allow them, through the expression of other parts of their personality or entertainment capabilities, to allow that to be threatened? If you can give us a quick rundown on that, I find it bizarre.
Yes, you're talking about our case challenging the University of Central Florida's decision to take away the scholarship of Donald De La Haye. My lights just went off in my office. I'm sorry about that. The reason they took it away is because he had this successful YouTube channel, and YouTube was running ads on his videos, and he was getting a little bit of money from that. And some of the videos involved him throwing a football. He's a kicker, but even even throwing the football on the beach with his girlfriend was too close to monetizing his college football career. And so the NCAA forced the school to kick him off the team and then they took away his scholarship.
Right.
And all for just expressing his First Amendment right to speak on YouTube.
Mm-hmm.
And of course, it violates NCAA rules essentially for a college athlete to have any job that capitalizes on their image.
Mm-hmm.
And so the restrictions that the NCAA placed on what he could say on YouTube were so onerous that he had to basically choose between his right to speak and his scholarship. And so he chose his right to speak, and we're trying to help him to not have to make that choice, to be able to exercise his First Amendment rights and still pursue his college education and his sports career too, hopefully. Because the breadth of what the NCAA rule and these public colleges that are enforcing it, the breadth of what this means is really striking. If he had written a book, an autobiography, he wouldn't be able to sell that. The rules that apply to Olympic athletes are not as onerous as the rules that apply to these NCAA athletes. And in the era of social media, it really has a chilling effect on their First Amendment rights in a profound way. And it's past time that we let them exercise their First Amendment rights and don't put them in a position to have to choose between their fundamental rights and their education.
Right, because ultimately that video that was monetized by a third party, and we're not talking about a lot of money, as I can tell you personally, that could have easily just have been about a political or civil rights issue, not just an entertainment issue. And the notion that the young man, who, from what I've read, deserves all the credit in the world. I mean, for a young man to take that type of stance really kind of gives you a a warm feeling about the youth of America. But his videos just as easily could have been about anything from Black Lives Matter to Puerto Rican nationalism to, quite honestly, on the other extreme, the alt-right or the alt-left. And the fact that there's a vehicle out there that will facilitate any of the production costs or anything out there, the notion that the NCAA exists in this monolith, this all-powerful Oz behind the curtain of college sports, it's time for that to change. Is the Goldwater Institute ready to engage in literally the steel cage death match of the century and go head on head with the much vaunted Mordor-based NCAA?
Well, we don't think that we have to do that. I mean, if they bring the fight to us, we're ready to throw down. But we think this is a narrower issue, and we think it really, if we apply some sensible rules that exist for other athletes and other individuals who have restrictions on how they can use their persona to generate money, you can still have some limits on what college athletes can do, but you can have limits that are not unconstitutional.
Right.
And so that's what we're after. The rules that they've imposed here are just so far beyond what the Constitution allows.
Right.
That we need to at least roll back this first step, and then somebody else can decide about the fate of the NCAA.
Well, and it's interesting because you've got so many of these powerful sports institutions that are really facing these type of challenges on a variety of levels, whether it be the NCAA, Major League Baseball, the NFL, who for generations have found themselves largely above the fray and exempt from a lot of the operating environmental rules, whether it be antitrust issues or First Amendment rights. And you starting to see, I believe, ultimately what needs to happen, which is that no one organization, which may have become and may still be fundamentally well-intentioned, no one organization with that type of power and that type of clout should exist in a society, in an open society, without fear of being challenged. They operate with impunity, and it's not surprising. And from a strictly competitive standpoint, when you look at the cost of running a sports operation or college, if you're operating at the Division I or Division II level, so many of these of college teams, and I don't weep for them because many of them are, basking in alumni money, but you have to have an almost SEC-like compliance operation supporting your track team and your lacrosse team as well as your football team, and quite frankly, it's gotten a little ludicrous. And the losers, I feel, are so many of these student athletes who, in my mind, my words, not my guess, but my mind, should be allowed to participate in ancillary profits because so few of them end up having a long-term career in that sport. And there's a significant percentage who never even are able, because of the demands of their athletic activities, are never even able to realize the one benefit they should, which is a well-earned, well-supported college education. And so,
well, our client made this point is that what he learned in his business classes was to be entrepreneurial, to go seize opportunities where they exist, and
right.
That's what he did with his YouTube videos. He met a market need for this entertainment that he was offering and these insights that he was offering, and people liked it. They subscribed, they watched it, and that's why he was getting paid. So he felt like he was living out the education that he was receiving, and the school penalized him for it.
Right.
So what message are we sending to young people when schools do that?
Exactly. Well, another topic for another night is what messages schools purport to send and what they really do send to our college-age youths. That's a tangled web. I know you've got commitments this evening. Jim Manley from the Goldwater Institute. As always, Jim, if you can give a couple of plugs for your organization, so when this video goes out, folks will have a chance. By the way, the website is spectacular. I've seen just over the couple of years that I've been following your organization, I've seen your organization evolve not just into this multi-front war machine fighting for personal liberty, but the communication, the delivery method you're doing is just, folks, don't waste your time on paywall, third-rate regional newspaper sites. Where can they read about your organization?
Well, thanks for that. We just redesigned the website, so that means a lot, I know, to the team that worked really hard on that. It's goldwaterinstitute.org, and you can learn more about all of the cases that we're pursuing and the policies that we're trying to enact in state legislatures across the country.
Right, and folks, whether it be righttotry.org, which is one of their supported websites where they're advocating for right to try legislation across the country, to their seminal efforts in fighting corporate cronyism, which is where I met Jim in effect for the first time digitally, to their efforts on behalf of free speech and fundamental constitutional rights in every single field of play, every single field of battle. They are providing a level of excellence that I think all of you should participate in. Jim, first of all, if for some reason I don't get a chance to talk to you for the holidays, Merry Christmas and Happy Hanukkah, whatever it is you choose to pursue over these holiday seasons, just you and the entire Goldwater family, just have a wonderful holiday. It's well-earned, and God bless.
Appreciate it. Same to you. Thanks for having me on. It's always a pleasure.
Folks, Jim Manley, and of course he is the senior attorney at goldwaterinstitute.org, a force for liberty across this country on so many fundamental issues. And and again, my remarks notwithstanding about crappy third-rate regional newspaper paywalled websites. Too close to home? Imagine a source where you could actually read original thoughts, original writing, where just like Reason and a handful of other sites that we work with so closely. It's just great stuff. And you know, you need, whether regardless of your political background, persuasion, immerse yourself in sites like these because they're fact-based, and they reflect an important argument that needs to be discussed and encountered whatever your personal background or your belief system is. They're challenging, yet accessible, they're interesting, and at the same time, they manage to find themselves in a position that I often talk about, whether it's the Goldwater, whether it's Reason, or even here at Go Local Prov. They are answering questions you didn't even know you had to ask yet. We're going to take a very brief break right now. This is the Coalition on the Worldwide Coalition Media Network, broadcasting live at the Go Local Live Broadcast Center, 90 Way Boston Street, in the heart of the city we love, Providence, Rhode Island. It's a chilly night, anticipating a little bit of snow tomorrow. How that translates into reality, we're not sure. But you know what? It's Friday night in the city. So, you know, who knows what tomorrow night brings us. So if you're still trying to think of your plans, there's some great places to go, you know, both downtown, on the east side, over on Broadway, Federal Hill, you know, Thayer Street, you know, the street that we love, Rhode Island's own buffet. It's a great night to go out and embrace New England on this night before a snowstorm. We're going to take just a quick break in which I'm going to be musing and chatting for a few minutes in the run-up. At 7 o'clock, Dan Fishman is going to be joining us. If you're a libertarian, if you're watching this now or this week coming up, Dan is well known to libertarians nationwide. He is from Massachusetts. And we're going to discuss his race for state auditor. He's going to explain to us a little bit of background as to what the state auditor's position is in Massachusetts. And we'll discuss a little bit about just what type of role folks here in Rhode Island are talking about legislation advocating for an inspector general. And we're going to talk about the scope and the breadth of that office as well as some of the challenges he faces. He's on one-on-one with a Democratic incumbent, and we'll talk a little bit more about that. Folks, stay tuned. We'll be back in just a few minutes.